versus Suarez. Please make your appearances.
Good morning, Your Honor. Jesus Suarez and Darcy Cohen. We are counsel to the plaintiff petitioner, Commissioner Joe Carollo.
Good morning, Your Honor. Raquel Rodriguez and Mario Reeds from McDonald Hopkins. We are counsel for the City of Miami and the City Clerk Todd Hannon.
Good morning, Your Honor. Marcos Jimenez for Miami's for Independent and Accountable Mayor Initiative, if I have that name right.
Do you have an acronym I could use?
Yes, we call ourselves Strong Miami.
That's right. Okay.
That's our website, strongmiami.com.
I will continue to use that without any intent to sway any votes on this matter.
Thank you.
Mr. Martinez.
Bob Martinez from the firm of Colson Dixon. I'm here on behalf of Mayor Suarez, along with my colleagues Carollo and Suarez.
And Your Honor, Orrin Rosenthal and Mike Valdez from Miami-Dade County Attorney's Office on behalf of the Supervisor of Election, Christina White.
Anybody else? Okay. Folks, I am happy to work as hard as I can to get all these things done. You cannot start putting things up at 9 o'clock at night and dropping them off 5 minutes before the hearing and expect me to be able to read everything. The care of meeting of judges is important. I am working alone, so I'm happy to read all of your things, but obviously I haven't gotten to it. I will tell you what I've read so far: the motion for protective order filed by Mayor Suarez, and I started to read the judgment on the pleadings. I read the motion, or there's two of them, and then I started to read the motion for appointment of the commissioner to take the depositions in the state of Massachusetts, which does not explain why Mr. Fleming's testimony is important, so I'm going to want that question answered. And Mr. Suarez, the other question I want answered is, I saw in the motion for protective order that Mayor Suarez filed an argument that the city commission independently put this ballot language on the ballot, and therefore the whole issue of whether the petitions were properly gathered or not is moot. I think that would help resolve a lot of issues if they're right. If they're wrong, that also helps resolve a lot of issues. So if you can address that point.
Your Honor, good morning. I'm happy to address that point. I saw it for the first time when it was, well, I believe there was a motion for protective order filed late last night, and there may be reference to it in the motion for judgment on the pleadings filed at 4:40 this morning. But there are two grounds that we would challenge that on. Factually, whether that is an accurate recitation of the facts, and legally, whether there is any discretion in the committee's, whether the commission, the city commission, has any discretion to put the matter on the ballot once the referendum initiative has been certified by the clerk, which we believe happened improperly here. As Exhibit J to our complaint and petition for writ of mandamus, Exhibit H, we have the actual text of the commission resolution. The commission text, the text of the actual resolution that caused the matter to be placed on the ballot was sponsored by Mayor Suarez. And in the fourth whereas clause, it states that whereas an initiative petition proposing amendments to the charter to change a strong mayor form of government has been certified by the Miami-Dade County Supervisor of Elections as having obtained the requisite number of signatures. Thereafter, the committee action, the city commission's action stems from that triggering mechanism. Certainly an argument that we're prepared to brief before Your Honor, and that we believe requires factual development through discovery.
Okay, Mr. Martinez, you want to defend your argument?
Your Honor, if I can address this court briefly, in bigger picture and before much greater argument in detail, I would like to defer to my partner, Frank Meadow. I spoke with Mr. Suarez, we all did this morning before the hearing, to see if we could agree to a schedule because it was the status conference and let us proceed orderly. And here's what we would like to propose to the court perspective. We can get our motions to dismiss, everybody can file their motion by tomorrow morning. Mr. Suarez can file his response by Monday. Yom Kippur goes to, I think, Wednesday. We could file our reply on Tuesday and respectfully request that the court set a hearing just on the motion on Thursday. We believe, of course, I disagree, that this is a legal issue which would basically take care of any discovery. When we agree to that, we think that what's either argument that the court will agree with that this is a schedule, and the court has agreed with us, the trial date the court has set for October 5th will still be viable. We would want to keep that date because it's sufficiently in advance of the election to allow the parties to appeal regardless of outcomes. So the bottom line is, by agreement with Mr. Suarez, we would like to file our motions, all of us, no later than tomorrow, let's say noon time. Let Mr. Suarez file his response by Monday, 5 o'clock, whatever time the court wishes. We can do a reply Tuesday and a hearing on those motions.
If you're in agreement with that, Smith?
I am in agreement with the schedule. I would like to be relieved of the 5 o'clock obligation on Monday, but I am in agreement with the schedule on the briefing components. And while we don't agree to abate discovery, I have no agreement rescheduling a discovery to sequence it in a way that makes sense. We certainly understand the mayor is very busy. We don't want to put any more undue imposition on his time than we have to, but we do not agree with abating discovery. I do agree to reschedule discovery so that the court can entertain motions.
Okay, we'll discuss discovery in a moment.
Yeah.
The only hitch with your proposed plan is I'm out of town starting Wednesday until Sunday. Well, I'm not sure I need a hearing once I get the papers. So the way I prefer to move on this is I'll get the papers, I'll read them. If there's something I think I need a hearing on, I'll schedule it. But if not, I'll just rule. And I don't know, I'll try to rule by the end of the weekend, but I am going to be on vacation, so I got to try to steal time away.
I'm actually going to be on vacation myself all next week. I was going to let Mr. Manuel better do the argument. What time is may I ask? What time is the court leaving? We'll get our reply.
As long as you put everything on e-courtesy, which I prefer anyway than hand delivering it, unless it's voluminous exhibits, then those I'd like to have hand delivered. I can read it anywhere, it doesn't matter. As long as I have an internet connection, I can review your pleadings. And I will have an internet connection. Okay. You said you were going to let Mr. Manuel make the point on the city commission.
If you want to hear it today?
I do want to start to try to resolve that issue.
Thank you, Your Honor. Frank Manuel for Mayor Suarez. Very basically, county ordinance, city ordinance section 2-112 presents two routes for the city to propose a charter amendment. Route number one, the city simply passes a commission resolution which directs the city attorney to draft the amendment. The city can pass that resolution of its own volition. It needs no further predicate. The second route, a petition of 10% of the voters is certified. Once that happens, the city attorney, without any action by the city commission, then is required to draft the resolution with 120 days. That second route never happened. What happened on August 6th is a special commission meeting was set. And at that point, there had been a certification of a petition, but because the commission didn't want to wait for that process to play out, it independently passed a resolution directing the city attorney to draft the proposed amendments. That is something that the city commission has the authority to do without any petition, and that is what it did do. And once that happened, the route that the city proceeded on was the route of the city commission proposing an amendment of its own volition. What happened on August 14th was the simple fact of placing the drafted proposed amendment on the ballot. Now, with regard to Mr. Suarez's argument about the whereas clause, it is true that the whereas clause for both resolutions, the August 6th resolution directing the city attorney to draft the proposed amendment, and the August 14th resolution placing that proposed amendment on the ballot, did include a whereas clause acknowledging the existence of the petition. It also included a second whereas clause saying that the commission wished to place this on the ballot, which it is allowed to do. Regardless, Your Honor, once the city commission takes it upon itself to pass that first resolution, which it has the complete authority to do, the courts and the case law is clear on this, we do not look into their motivation. We do not ask, well, what role did this pending petition play? That is the whole point of the doctrine of legislative acts. Unless you have any further questions, that's pretty much a summary of what
Okay, Mr. Jimenez.
May I chime in just briefly?
Please.
I think the question that the board asked initially was in our motion for protective order, which is the first one that was filed last night at 6:07.
I read it here. That doesn't mean you didn't raise it also, but I read it here. I just don't recall who filed this one.
But in any event,
No, this is Mr. Martinez.
it's in the mayor's motion also.
Yeah, right.
I wanted to say that what Mr. Matterall said is also consistent with, it's not just a city ordinance, but there's a county charter provision, which is section 603, 6.03, which also says that you can have either a resolution adopted or you can have a certification of petition. Those are two alternative routes. So the city ordinance and the county charter are the same, and those are the ones that apply. And I'm not going to get into the motion for judgment on the pleadings that we filed very early this morning, but we've already applied with the process that the board, the parties have agreed with in terms of getting our motion. But let me take a step back and just talk briefly about the overall picture of this. Everyone agrees, and even counsel for the plaintiff last week said that they're all legal issues except for count 3. Count 3 alleges that some of the petition gatherers, which are called circulators, were not registered electors of the county. That's all it alleges. So our position is simple. There should be no discovery because no discovery should be taken on purely legal issues. And as to that issue, we've not only advanced the mootness argument that we've already talked about, and I won't belabor anymore, but we've also made it clear that we have, and once you read our motion for judgment on the pleadings, that there are legal issues there as well that should be resolved. In 1223, our position is, does it even apply? We simply used it as a guide for drafting the form of the petition, and the petition is attached to the complaint. And all the circulators affirmed is that they had gathered a signature that was valid, that was a voting person in the city. And no signature of a petition signer has been challenged. So it's all about whether or not these people who handed out or sought to get signatures were registered electors of the county under a county ordinance that we say doesn't govern. And we've got constitutional arguments as well, which I won't get into at this point. But those legal issues on count 3 should be resolved. Even if there was, at the end of the day, after those legal issues are resolved, some sort of factual issue with that count. At the most, it would be, what were these guys, or gals, or people, registered electors or not, the petition gatherers, circulators.
Which is an objective fact.
Which
established one way or the other.
Exactly, and the plaintiff has already asked the city clerk, as we said in our motion, to go to the supervisor of elections and get that information. And our understanding is that that is underway, so you don't even need a discovery request. But they have a discovery request on that. They have an interrogatory to the city clerk. So at the most, what we should have here is an interrogatory, not 20 depositions, including one in Massachusetts. It just doesn't make any sense. So that's our position on discovery.
Thank you, Mr. Chairman. Ms. Rodriguez, when is Mr. Hannon going to be able to provide the information on the certification of the elector?
Well, Your Honor, the certification already occurred.
Yeah, I said that wrong. Not the but they have to be registered voters, right? The circulators?
Actually not. As council have explained under both the city charter as well as the county code, and actually under Florida statutes 166.031, the triggering event is that 10% of the registered electors of the city sign petitions requesting the amendment. So there is nothing in the city charter or the state statute that creates the fundamental right of the citizens to petition for an amendment of the city charter that imposes any requirements with regard to petition circulators. It is simply not part of the process, and it was not part of the process that the clerk of the city used in his ministerial role as the administrator of elections. So it was not a factor at all.
But Mr. Suarez, your argument is that the circulators themselves have to be eligible voters?
My argument is that under the county code, the circulators have to be registered voters.
Okay. So is Mr. Hannon trying to, I understood from the hearing last week, Mr. Hannon was going to figure out whether in fact, whether the argument's valid or not, just so we can move the ball down the field, whether the circulators were in fact registered voters.
That is correct. He was asked by Commissioner Carollo at a city commission meeting to identify how many of the petition circulators were registered electors of the city and how many were not. So in the normal course of the clerk's duty, responding to a superior, the office is doing that. They started it. They've got about another week or two left in the normal course. Of course, they have many other duties, but they are working hard. One part of the task that the commissioner requested already was completed, which was to ask the supervisor of elections to provide information on whether or not they could confirm whether a petition circulator was a registered elector. And that information has been obtained and will be provided. And so the second part, I think, that the commissioner requested, and which comprises the interrogatory request, is to tie particular petition circulators to specific petitions. I assume so that the plaintiff can argue that there's an insufficient number of petitions. Again, that is being addressed through the normal course of the city's clerk's business in response to the commissioner's request, and that is the process that is going to take about another week or two to complete it. They have been working on it diligently.
Thank you, Bert. Anything else you wanted to say?
Your Honor, just that I apologize for filing our motion for protective order late yesterday. We just got retained earlier this week, and we've been working hard to get up to speed. And we joined in the requests of the mayor and the strong Miami to defer all discovery until Your Honor has had a chance to assess what are the issues before the court, and also to defer the deposition of the city clerk under the APEX doctrine until the plaintiffs can establish that he has information that they cannot obtain by any other means.
Okay. Thank you very much. All right, Mr. Suarez.
Your Honor, I'd like to address a couple of points.
Okay.
I understand that the city recently retained Ms. Rodriguez as outside counsel, and I know that the city is working diligently to provide responses to the information that we've requested and that would properly be available through a public records request. I framed it through discovery, in this case, understanding that the clerk is now represented by outside counsel, the city is represented by outside counsel, and I'd like to be very careful in not engaging in public records requests with the very same folks that were in two-party litigation with here, or that may ultimately be witnesses before the court. So to the extent that we have framed our discovery requests as such, that's the reason
I don't
why.
think they're complaining about the vehicle, they're complaining about the content.
The content, which I believe they admit is a matter of public record, and that Mr. Carollo would have the right as a commissioner to request this information from the clerk in any event. But I'd like to take a step back and focus really the impetus of our complaint in terms of why this discovery is necessary in the first place and how it relates to our claims. It's true that there are some claims that are purely legal issues. The ballot language is what it is, and I think you all can determine square on the law whether under the long line of decisions from the Florida Supreme Court it's misleading and it hides the ball. We're prepared to show Your Honor why that is the case. But the evidentiary counts of our complaint, which is that the city fundamentally failed, either through the committee and the mayor, to give effect to the laws that are in place for the conduct of these sorts of initiative and referendums, isn't mooted by any of the arguments that I've heard today. And in response, I'd like to hand the court the case of In re the matter of the protest of election results and absentee ballots in the November 4th, 1997 election for the city of Miami. I apologize, I printed this out this morning, so I only have one copy for all of the other council assembled. This case had to do with court invalidating an election because of massive noncompliance with the county's and indeed Florida law on absentee ballots. It involved an election for the city of Miami, to which Commissioner Carollo was a party. And in this case, the 3rd DCA undertook in its reasoning that overturning an election, involving yourself in the democratic process, is something that courts ought to do sparingly, but that when it comes to protecting the integrity of the ballot, that it's not something that a court should hesitate to do. And that's what we're asking the court to do in this case. Because I read Mr. Cuney's motion for judgment on the pleadings this morning, and I've read papers that opposing counsel has filed, and there's one thing that's true, is that this has been framed as a citizens initiative, as a uprising of popular support for this concept of a strong mayor. But that's not the case. And the reason that that's not the case informs the court as to why none of the county ordinances were followed, despite the fact that the committee, in its submission to the city, invoked County Ordinance 12-23, despite the fact that the city attorney has opined that County Ordinance 12-23 applies in this case. And it dovetails right into the concept of why we need the motion to appoint a commissioner. This wasn't a popular uprising of people that all of a sudden decided they needed to have a strong mayor. This was a mayor who picked his political allies to form a committee that was organized by a gentleman who's a resident of the city of Coral Gables, who then hired a law firm in Tallahassee to submit petitions on behalf of committee members to the city clerk pursuant to County Ordinance 12-23. The committee then apparently completely disregarded the county's rules for gathering petitions, which not only includes being a registered elector in the county of Miami-Dade in order to circulate petitions, but that includes something as simple as having a text of the charter amendment with you in English, Spanish, and Creole when you circulate the petitions. The committee, after hiring a Tallahassee law firm, goes out to Massachusetts and hires a gentleman, Mr. Fleming, whose deposition we'd like to take, whose business it is to travel the country collecting petitions for folks in a professional manner. He's a paid petition gatherer. He's a political operative in Massachusetts who came down to Miami-Dade, the city of Miami, and hired a bunch of folks to collect petitions for him. I would ask the committee how many, if any, of their petition circulators were citizens that had a common interest in having a strong mayor. They weren't. They were paid petition gatherers. Now that's fine, and that's legal. But if the court determines that the committee came in under false pretense and completely disregarded the election laws of the county of Miami-Dade to the point where there has been given no effect to the rules for conducting a petition gathering process in this county, the court, under its equitable powers, can decide that that's not a matter that has been properly brought before the voters. And it would be our position that unless the parties are willing to stipulate that there has been a complete non-compliance with all the ordinances, that the court ought to allow us discovery in order to develop the facts that we need to present to Your Honor at a final hearing or trial on this matter. Setting that issue aside.
No, I want to stay on that issue. I just wanted you to be done.
All right.
So I hear you trying to tell me that I should be getting involved in the political aspects of this petition, that I should use the Elder Suarez Carollo race from '97 as some sort of template, that when there's voter fraud, I can set aside an election, and here essentially preemptively set aside the election. And I don't see any connection between fraud at the ballot box and whether someone has been misled as to the origins of a petition. That seems like a political issue, and it's going to come as a shock to everyone that not everything said during the battles for elections and petitions is accurate. And that's up to the voters to determine what's accurate and what's not. How do I get involved in that?
Not the issue of the accuracy. It's the issue of failing completely, lock, stock, and barrel, to comply with applicable law for the process for circulating.
I get that that's your argument, Mr. Suarez, but you started this by saying this has been sold to the public as an uprising by the citizens that they demand a strong mayor. Frankly, that's not my experience. I remember when Mayor Suarez was running, he ran on this as one of his issues, that he thought there should be a strong mayor. But setting that aside, let's assume it's been sold to the public like this. Lots of things get sold to the public. Where's the role for the judiciary to step in? And you want truth in politics is what it sounds like.
I'm not asking
That's
for
not my
truth.
role.
We're asking for an election to comply with the rules, to comply with the laws of this county. If this measure made it to the ballot through a process that from day one was undertaken without compliance with the county ordinances, compliance that gives due process to the voters, to Commissioner Carollo, whose office is being impaired by this proposed amendment, that is something that the court ought to consider, whether there has been compliance with the rules for getting this amendment on the ballot. I'm not asking your court.
That I do not
Yes.
disagree with. That,
Correct.
that we can focus on, and that's why I think the first focus is on the argument that's been raised by the other side that, listen, we don't need to rely on the petition. The commission did it on their own. They directed the city attorney to generate the language, and therefore it's moot whether the petition gathering was proper or not. I think that's my first inflection point. I need to rule on that, and I think that then puts everything in terms of discovery, brings it into focus. I just thought your argument was a bit broader than that, and if there's a role for the judiciary, so be it. I don't think so.
No, our role, our complaint to the court is squarely with the compliance by the committee and the city with the rules of the game for putting this thing on the ballot. But I colored my remarks with the additional facts because the minute that you pick up a pleading by the Strong Miami Committee, the strength of the argument is let the voters decide, the people want this. This has been some sort of argument on my part, organic process, when in reality this has been carefully designed in this way.
But even if, and I would then tell them the same thing, even if everybody in Miami wants this on the ballot, if the process is not followed and it's not legal, then the judiciary does have a role there.
That's all we're asking the court to do.
Okay. So, the only factual dispute then is if it is relevant that the petition gatherers were not, or the circulators were not, in fact, registered electors, if that's a relevant point, which is the first issue I'm going to focus on in terms of the law, then what discovery do you need? Why do you need to take anybody's deposition if the city clerk, Mr. Hannon, can tell you if they were or they were not?
That's not our only complaint. The complaint goes beyond the electors being, the petition circulators being registered electors. It also goes to non-compliance with the county ordinance as it relates to having the text of the amendment present, as to the other practices that were employed by the petition circulators.
Let's take them one at a time. So the first issue is whether the text of the amendment was actually on the document that's being signed by the voters, right?
Well, it's attached.
Okay.
It needs to be attached.
So what's the factual dispute? Doesn't it get submitted with the language attached?
Whether or not they comply with that, correct.
Okay, wouldn't it just be a corporate rep, I guess, from the city clerk's office who would tell you they were not, or they just produced them to you?
Here's how it would work, and I've got the copy of the petition attached to the complaint at Exhibit E.
I don't have it. I'd have to put it up on my computer.
I can hand it up to your own.
Wait, thank you.
May I just ask a point of clarification?
Yeah.
Where is that alleged that the entire initiative has to be attached to the ballot, to the petition?
That I do not recall. I do recall an allegation that it was only, I think, in Spanish, but not in English and Creole, or in English, but not in Spanish and Creole. I remember that allegation.
Yeah, this is new to me, so if Mr. Suarez can enlighten me or point me to the right part of the complaint I may have missed.
Sure. Paragraph 52. The petition circulated by the committee did not contain the title and text in English of the charter provisions sought to be enacted or repealed.
Okay, that's not what I heard him say, which is that you have to provide in English, Spanish, and Creole.
Well, I can't
Yeah.
in Spanish or Creole, but it says the same thing in Spanish and I presume in Creole.
So what is your reason for believing that they wasn't attached?
My understanding is that it was not attached to any petition that was
At all?
circulated.
Okay. And when they're submitted to the city clerk, they should be attached, right?
No, when they're submitted to the city clerk, the clerk gets the signed petition together with the affirmation, the 12- certificate of truthfulness, 1223 of the
So
Code of
who are you-
Miami-Dade County.
How? I mean, 10% of the voters, what was the final tally? What did it need to be?
Well, I'm not disputing that they've submitted 10,000 verified petitions.
No, that's not my
however
question.
many it is.
How many are there? How many petitions were submitted?
I believe there were 19, it's here attached to the.
Okay, that's what I want to know, 20,000 ballpark.
20,000 ballpark.
How are you going to establish that that they weren't attached to 20,000 of them? Who are you going to depose?
Well, Your Honor, we'll ask the committee members what procedures they put in place, whether anybody paid to have copies of all of those charter
Okay,
amendments.
so through the Strong Miami, you want to do that. Why can't you do it through a corporate rep? Why do you have to depose each one of them?
Mr. Arhiz, who is the resident of the city of Coral Gables, is the person who's been designated as a corporate rep. We think that's inappropriate, and I'll explain to Your Honor why. Exhibit D to my complaint, the committee's affidavit, letter submitted by the Tallahassee law firm that initiated the petition, pursuant to section 12-23 of the Miami-Dade County Code of Ordinances. There's a submission of the affidavits. The affidavits that are submitted are from the 5 committee members, not Mr. Arhiz, not someone they could legally rely on because he's not a resident of the city of Miami. And at a minimum, we should have the opportunity to have a representative from the committee testify.
But corporations decide who their corporate representative is. You don't get to decide it. They pick it and it binds them. So again, why can't you, and maybe they will designate Mr. Arhiz, maybe they won't. I don't know. It's up to them. Why can't I just order the deposition of the corporate rep and then they're bound by the answers?
I would be, I'd be pleased to take that corporate rep deposition and then come back to the board just further
That makes
to challenge that.
sense. Okay. And now, what's Mr. Fleming going to testify about? That he came down here, he's not from Florida. You're going to accuse him of being a carpetbagger, I guess.
Mr. Fleming is the paid interloper who came down and circulated
What is the relevance of that?
I will hold my request to depose him in abeyance pending testimony from the corporate representative.
Okay. And you're already agreeing to hold off on Mr. Carollo and Mr. Suarez and Mr. Hammond, right?
I've got no objection with sequencing those depositions later on so that we can take other discovery.
Who else do you need in the meantime?
In the meantime, we've subpoenaed 4 petition circulators. I know that we've perfected service over 2 of them. I'd like to go ahead with those depositions on Monday as they've been noticed. And then we'll come back to the court if we think we need them.
And that's it? So now we're down to just 2 circulators?
We have also noticed for deposition a number of the folks that were involved in actually giving effect to the committee's proposal. But understanding Your Honor's view of the committee's rep, I would agree to take that deposition first and then come back to the court if there's a need for further discovery.
Okay. So, anyone on that side, anybody objecting to the circulators being deposed on Monday?
Yes, Your Honor, we strongly object for the reasons that we set forth in our motion.
I haven't read it yet.
Huh?
Haven't read it yet.
Oh, yes. Well, my motion is 4 pages, so try to make it short.
Okay. I appreciate that. Okay.
But number 1, the only issue that's alleged is can be even this additional one about not containing the title text in English, the charter provisions ought to be repealed. That's obvious with this petition. We've already talked about the petition circulators. Whether or not they are registered electors or not, is going to be determined by the clerk. Why do you have to depose them? There's no need for their deposition. And we've already discussed our legal issues, which are it's moot because our position is that County Code Section 1223 does not apply to city elections. We simply followed it as a guide. That's in our motion for judgment on the pleadings. there's a constitutional issue that individuals who are paid or want to express whatever they want to go ahead and circulate petitions are allowed to in this country under the First Amendment. So those issues have to be resolved before we even get to whether or not the factual issue matters. And then we have the mootness issue, which is what the court has to, the fork in the road, the court has to determine. So those should be resolved before we have any depositions of petition gatherers, circulators, clerks, mayors, anybody.
Has the constitutional issue been raised or been decided by any other courts?
Your Honor, we cited Buckley versus Vallejo, I believe it is in our...
1972. I'm thinking post-Reed, because it seems to me like you're probably right under
Yes.
Reed.
But we need to, we're happy to supplement that with additional case law, but we were trying to comply with our own deadline of getting the motion filed before this morning, so we're happy to further brief that issue.
Have you looked at this First Amendment issue? I mean, after Reed, it's really hard to forbid people based on content from speaking. Really hard.
We're not asking to forbid anybody from speaking. We're not asking the court. We're asking to take a couple of depositions of folks that...
No, I know that. I'm saying, what you're saying is these folks didn't have the right to walk up to their fellow citizens, regardless of what state they're from, and ask them to sign a petition.
Your Honor, I think my argument is the committee didn't have a right to come into the city of Miami and organize a process that didn't comply with the laws of this county.
That is going to be a losing argument. Because I've already written on, I had to write an opinion on the homeless walking up to people, or anybody walking up to people in the city of downtown Miami and asking for money. You cannot prevent them because Reed is a sea change in the law in the First Amendment.
Nobody is suggesting that the court prevent them or that they cannot do it. Our argument is that the failure of the committee to organize and submit the petitions in accordance with county law is what creates that declaration. And, Your Honor, it's no different than folks having the right to vote, but there being a requirement that they register and that they come to the polls and that they follow county ordinance and state statute in connection with exercising that vote.
I'll let you brief.
Thank you.
What I'm going to do is I'll give you all a ruling within a day or two on the deposition on your motion for protective order. I'll get a chance to read it. Have you had a chance to respond to it?
I have not.
Okay, you want to do that by the end of today? You don't have to. I mean, I know what your position is on why you're taking their depositions, but if you want to, I'll hold off. I won't rule before tomorrow.
The only exception that I would take, and I would ask Your Honor to consider, is the noticing of a corporate rep. We do think we've got the ability to designate a representative, and I understand Your Honor.
Honestly, it's not my view. That's Rule B6. You just don't.
I respect that.
And it's actually error to put somebody's name on. I will strike it if you do that. So don't do it. Let them pick their corporate rep.
Okay.
That's why they're bound, because they picked. You didn't. If you picked, you can't find them.
Understood.
You get the right to depose anybody you want, but they get to pick their corporate rep.
We'll start with their corporate rep.
Okay.
Your Honor, just as you're considering the various motions for protective order, on behalf of the city and the taxpayers, we would request that you consider the expense that will be undertaken if we have premature or unnecessary discovery before Your Honor has an opportunity to consider the legal issues that are raised by the parties' motions.
Yeah. The tension I have with Rodriguez is having to get this done quickly, so that there is appellate review. I like people to check my work, and I don't want to put that off. So I'm trying to counterbalance both. But I agree with you. I don't want depositions being taken unnecessarily. I am a city resident, so I don't want to spend all that money either.
We appreciate your honor.
And just on behalf of the county, Your Honor, all these agreements on discovery and the issues we litigated in this case, I have no issue with. We have no dog in that fight. However, we do have a dog in the fight to the extent 1223 is found to apply the constitutional issue. Just on the general issue of judicial conservatism and not reaching constitutional issues and constitutional avoidance, I would ask you not take that issue until the very end, because if we have to come in and brief that, we will. But I don't necessarily know that's going to be an issue or not an issue on the case given some of the other matters.
Yeah. Again, I think the inflection point right now is whether the city commission could independently put this on the ballot, or did, and therefore everything else related to that is moot. Okay. Anything else you wish to say, Mr. Suarez? You have 3 minutes.
Yes, I'd like to confirm Your Honor's ruling and our understanding of the corporate representative deposition for the committee. Is it Your Honor's testimony that that can go forward? I'm sorry, Your Honor's ruling that that can go forward?
Yes.
Okay.
Corporate rep, have you all picked a date?
Your Honor, we object to that under, based on our motion for preemptive order, we have not confirmed the date. If the court's gonna order that to take place, just want to make sure it's over our objection.
Well, that's assuming that I allow it, but it will
Yes.
be just with the corporate rep. That one you should set for like the end of next week at the earliest, because that'll give me time to rule on the preliminary issue, and then if it becomes moot, it becomes moot, and if it doesn't, then you take the depo, but it only as a corporate rep.
And then the final issue would be our motion to expedite discovery. We would like to shorten the time frame for the written discovery to be produced by the parties.
Your Honor, there are over 100 different document requests in the 3 different requests for production that have been submitted to the city, to the mayor, and to the Strong Miami Commission.
And have these been attached to the motion for protective order?
We attached the link to the city.
We listed it, but we did not attach the actual request. I will do that.
Well, you don't need to attach it if you quoted it, as long as you quoted it
We did
verbatim.
not.
Okay, yeah, then.
We will supplement that with an additional exhibit.
Okay, I'll get to those. I'll start ruling on motions for protective order. You'll start getting ruling for the end of the weekend. You'll know what I'm granting and what I'm not.
Understood. Thank you.
Anything else?
Just to make sure we have agreement on the schedule with
Yeah.
regards to the briefing on the motions. We will have our motions in, all the motions in by tomorrow at noon.
Okay.
And if the plaintiff can have the response by Monday at 5 o'clock.
I'd like close of business on Monday, if that's all right with you.
Then we could have close.
I'm sorry, end of day.
I understand.
You understood me.
And we could have until Tuesday night or Wednesday at 9 o'clock. Will that give you enough
That's
time
plenty.
for the reply?
Put them up on, put up all these documents on proposed orders, any courtesy. That way I'll have one folder where they all land.
Thank you very much, Ron. Have a nice day.
One more issue, just procedurally and scheduling. I understand that that's the briefing schedule we've agreed to for the to-be-filed motions to dismiss, and that does not apply to the motion for judgment on the pleadings that was filed this morning by the Strong Miami Committee. That motion isn't properly before the court. The pleadings aren't closed. They're
I
under.
thought they answered.
They did answer.
Right, but we still have the ability to direct a motion at the pleadings under Rule 1.140.
So let me ask this, Mr. Jimenez, why don't I just consider your judgment on the pleadings as a motion to dismiss?
That's fine, Professor.
Okay, so treat it as a motion to dismiss.
Thank you, Your Honor.
Okay, anything else? All right, folks, thank you very much.
Thank you for your time, Ron.